At LJ, we make your problems go away.
Hi everybody, and welcome to another episode of LJ Law, Family Law TV. My name is Bonnie Leonardo, and I am your host. Today's topic deals with handling overseas property during a divorce. Although this is a tricky and oftentimes confusing part of a divorce whenever we deal with any overseas property, it is not an impossibility. Some of the most common types of overseas properties that I deal with in my divorces are bank accounts, investment properties, second homes, and oftentimes plots of land. The one thing I want you to understand is that assets such as home, land, and investment properties, they're often subject to the laws of the country in which they are located. The financial accounts and personal property are typically subject to the laws of the country in which the divorce was filed. So for example, here in Nevada is what we're talking about. During the divorce, both parties have an obligation to disclose all of their financial information for purposes of an equitable distribution. This includes listing all assets and all debts that each party holds, either separate or community. Although the parties are under an obligation to disclose all their assets, it doesn't necessarily follow that they always disclose assets. Oftentimes, we're faced with spouses who either completely fail to disclose an asset or they lie about the value of that asset. For this reason, I counsel my clients to conduct their due diligence prior to filing for the divorce. I ask clients to make a list of all the assets, account numbers, and values that they have in order to ensure that those assets are included in the divorce and are able to then be equitably divided. Generally speaking, before the court can have authority to make a binding order for the parties to follow, the court must have jurisdiction over the party and over the property. Although the courts cannot directly control division of properties in another country, the courts will have a right to divide it indirectly, and thus compelling the division by way of having jurisdiction over the parties. For example, let's say that the court deems that a particular overseas property belonging to the community estate is valued at $100,000. It can give that $100,000 credit to the other spouse. So I don't want you to necessarily think that because the property may be located in another country, that the court does not have power to equitably divide it. If the court has jurisdiction over the parties, it is likely that the court can have and make orders regarding the division of that asset. If you have questions about this bit of a complicated topic, don't hesitate to reach out to me. Go to vegasdivorcemeeting.com and I will be happy to discuss your particular situation in an attempt to help you have a better outcome. So as always, I would like to thank you for watching, and I will see you next time.
At LJ, we make your problems go away.